everybody. I just want to say a very quick word about the origins of this event, because we are very grateful to ASIL for hosting this event, but I also wanted to mention Young ICCA, a below 40 organization of the ICCA society. And this event was actually planned within the mentoring group of the Young ICCA mentoring program with Eduardo Zuleta as the mentor, and both Gustavo and I formed part of this group, and this is how we came up with the idea and organized this event. So with this, I just wanted to introduce Gustavo, who is Brazilian, and he is currently a research fellow at the Department of International Law and Dispute Resolution of the Max Planck Institute in Luxembourg for international European and regulatory procedural law. And he's a PhD candidate at the University of Luxembourg. So Gustavo will moderate today's panel, and he will introduce the speakers. Thank you very much, and I hope you enjoy the event.
Thank you, Laura. I'm glad to moderate this panel today. So first, I would like to welcome our speakers. First, Martin Doe. Martin Doe Rodriguez serves as Senior Legal Counsel at the Permanent Court of Arbitration in The Hague. He heads the Latin American practice of the organization, and he's a member of the drafting team of the Hague Rules on Business and Human Rights Arbitration. Martin will give us an introduction to the Hague Rules and their main procedural innovations. Second, we welcome Suzanne Spears. Suzanne Spears is a partner at Allen & Overy in London, where she acts in the International Arbitration Group and as a co-head of the Global Business and Human Rights practice. Suzanne will provide us with her intake on the increasingly frequent appearance of human rights issues in commercial and investor state arbitration. Third, we are glad to have with us Christy Hoffman. Christy is the Uni Global Union's General Secretary. She's a negotiator with long-lasting experience of closing deals with local companies, multinationals, and global agreements. She negotiated the provisions in the Bangladesh Accord concerning arbitration. Christy will therefore approach how arbitrating business and human rights disputes would be of interest to rights holders, explain what the Bangladesh Accord is and the reasons for opting for an arbitration clause in the accord. And fourth, we are happy to welcome Eduardo Zuleta. Eduardo focuses his practice in national and international arbitration, international litigation, public and private international law. He's vice president of the International Court of Arbitration of the ICC and member of the list of arbitrators of the ICCA appointed by the government of Colombia. Eduardo will approach the challenge of arbitrating business and human rights disputes in Latin America. Each speaker will firstly present their topics for 8 to 10 minutes around this time, and afterwards we will select some questions to address to the panel if we have time. So therefore, for the interest of time, I give the floor to Martin Doe, who will give us an introduction to the Hague Rules on Business and Human Rights Arbitration. Martin, the floor is yours.
There we go. Always the first step in joining these events, but allow me to reiterate my thanks for having me here, and to launch right in there. I would say that the story of the Hague Rules on Business and Human Rights Arbitration starts with the Bangladesh Accords arbitrations. It actually starts much earlier, but that's a good point of departure for today's discussion. These were, I would say, the quote unquote proof of concept for business and human rights arbitration, both as to the need for dispute resolution in this space and arbitration suitability for it, as well as the feasibility of actually conducting business and human rights arbitrations. Now, these Bangladesh Accord arbitrations were conducted under the UNCITRAL arbitration rules and worked relatively well under those rules. I might mention that the UNCITRAL rules have already proven themselves to be flexible enough to be used in commercial arbitration, in investor-state arbitration, and even in interstate arbitrations that we've seen at the PCA over more than a century there. However, this doesn't actually mean that the UNCITRAL rules are ideally suited to any of these specific contexts the PCA itself has promulgated quite a number of specialized sets of rules for different contexts, including for for interstate cases, for commercial cases involving intergovernmental organizations, for environmental and outer space disputes. And likewise, we could see in the Bangladesh Accord arbitrations that the UNCITRAL rules, while flexible enough to do the job in those cases, were not necessarily ideal for such a specific context. In fact, the tribunal in the Bangladesh Accord arbitrations acknowledged this precise point, and I quote, they said, "In the tribunal's view, this case cannot be characterized as either a public law arbitration involving a state as party or a traditional commercial arbitration involving private parties and interests, or even as a typical labor dispute." So they themselves were recognizing that the UNCITRAL rules and their broad discretion within that space wasn't enough to allow them to do exactly what they would like to do and what they think is appropriate. And that challenge was already reflected when they had to tackle the issue of transparency in the Bangladesh Accord arbitrations. They took the positions that were put forward by the parties and in fact crafted a very interesting compromise solution between the desire for transparency that arises from public interest and the desire for privacy and reputational protection on the part of the respondents in those cases. Once again, quoting the tribunal there, they said there is a genuine public interest in the accord, including on the part of other stakeholders who would have a direct interest in its interpretation. On the other hand, the tribunal must take into account competing factors stemming from the language of the accord and the practice under it, which point to an obligation to protect certain information about the participating brand companies. And so they sought to find a middle road that protected the reputation of the respondent brands, while at the same time acknowledging the public interest and indeed the objectives that were being sought to be fulfilled by the accord. That said, interestingly, right after crafting this compromise position that sought to balance these objectives, they then ran into the constraints imposed by the UNCITRAL rules themselves, namely confidential hearings and a confidential award, regardless of what the tribunal might have otherwise wished to do in terms of protecting certain portions of a hearing, anonymizing awards, allowing certain portions of an eventual decision to be made public in such a way that it does not necessarily contravene the interests in reputational protection of the brands themselves. So right there, I think we have the demonstration of why the Hague Rules project was undertaken was precisely to then take the UNCITRAL rules and to adapt them to this very specific context. And the Hague Rules project really had as its aim or its driving mandate was to take the requirements of the UN Guiding Principles, Principle 31, i.e. the requirements for non-state-based grievance mechanisms, and map those onto the UNCITRAL rules, while also preserving what are the advantages of arbitration used in these various different spaces. So what are those requirements? Well, UNGP 31 requires non-state-based grievance mechanisms to be legitimate, accessible, predictable, equitable, transparent, rights compatible, and finally, a source of continuous learning. So what did the Hague Rules do in this space? Well, taking accessible and equitable as the first two requirements, they looked in particular at many instances where equality of arms considerations might be in play, especially in V2B disputes between businesses directly with rights holders, instead of relying solely on formal equality. And I might then mention that this tracks well with neutrality as an objective of arbitration. Turning to legitimacy and predictability, well, The Hague Rules sought to ensure that expert arbitrators versed in the specific subject matter of these disputes would be appointed, and that they would be subject to a rigorous code of conduct. And again, I think this would speak to the expertise objective of arbitration as a dispute resolution means. Speaking to transparency and a source of continuous learning, well, the Hague Rules provide for broad transparency as a default starting point, but then contemplate quite a number of tailored exceptions throughout the entirety of the rules, including in both the interests of businesses and rights holders and their representatives who might also have an interest in privacy. And in fact, that also reflects flexibility as a trait of arbitration that we all know. And finally, rights compatibility. And that is a procedural requirement that's baked into the rules throughout, and frankly is something that the Hague Rules drafting team considered to be in line with the objective of enforceability within arbitration, precisely because public policy might undermine enforceability otherwise. And to then tackle the second question that I've been asked to comment upon, and that maybe we'll get to explore a little bit later, is why was the Hague Rules drafting team optimistic about the possibilities for arbitration in this space? And in particular, since arbitration is consent-based, why would we expect businesses and rights holders to meet in the middle in this space? And in particular, why would we expect businesses to be interested in consenting to arbitration where claims are predominantly going to be brought against businesses in this space? And I think there's 4 reasons. The first is you obviously have forward-thinking businesses, and we'd all hope that there are more of these as time goes on. But there should be enough of them to believe that more initiatives like the Bangladesh Accords should come into being. Second, you have those forward-thinking businesses participating in supply chains, or in fact, participating as lenders, who then take more seriously the UN Guiding Principles directive to look at where they cause, contribute, or are directly linked to human rights abuses. And as we've seen in the last year, the ESG revolution is upon us. We're on the eve of COP26 in Glasgow. There are more businesses that will demand their business partners to, in fact, make sure that they are above board in this sense. The third reason that I might comment upon is what I like to call the social license conundrum. And that is where there might be a large investment project, resource, or infrastructure on one side that a business wants to undertake. There is a community that, fearful for being adversely affected, feels that they have to oppose such a project. And as a result, this project gets blocked by social conflict, and generally public authorities may side with one side or the other, but often are caught in the middle there. And it may precisely be in trying to unblock those kinds of conflicts that a business says, I want this to go ahead. I am willing to offer access to remedy in order to allow it to do so. And then finally, I would say that there are going to be instances where clearly businesses will have to contemplate that there will be claims against them, and that they will prefer to use arbitration over litigation in national courts, especially in foreign national courts. And we've seen some pretty high-profile cases before the UK Supreme Court, the Canadian Supreme Court. We've seen legislative developments in France, some on the horizon in the EU, and indeed various cases where, in fact, the investor consented to counterclaims being brought by the state in investor-state arbitration. And all of this, I think, is why I remain optimistic and indeed think that this is a worthwhile project that will see fruit in the near future. I think that might be a good point to pass the baton to Suzanne. Thank you.
Thank you very much, Martin. Just before giving the floor to Suzanne, I just would like to clarify for the audience that the Q&A option on Zoom is open, and we are happy to receive questions from the audience. So now, Suzanne, the floor is yours to introduce us to the increasingly frequent appearance of human rights issues in commercial and investor state arbitration.
Thanks very much, Gustavo, and also thank you to Martin. And I'll pick up on some of the comments that Martin made, particularly when I get to talk about the potential for commercial arbitration to increasingly address human rights issues. But starting with investor state arbitration, it is true we are seeing some increase in the appearance of human rights issues in investor state arbitration, but one should situate that in the broader context of investor state arbitration and recognize that investment treaties have traditionally been called treaties that protect the human right to property of investors in the host states where they operate. So governments that sign investment treaties are needing to basically balance the rights that protect investors, while at the same time balancing that with the rights of host communities and the human rights of host communities. And this is something that has contributed, I think, to the rise of these issues increasingly appearing in investor state arbitration. Yet, while there are some 3,000 investor state or investment treaties, the majority of them fail to provide any guidance as to how the issues of human rights should be addressed in the context of investment protection and promotion. And again, this is a challenge because the issues that arise in investor state arbitration often focus on the regulatory space of states. And indeed, states' steps to protect society are often implicated in investor state arbitration. Just to raise an example, and I was asked to try and focus on Latin America, in an early example was a case against Uruguay, where Uruguay was taking steps to protect the health of the population by imposing plain packaging regulation on a tobacco company. And these measures ultimately were deemed not to be a violation of the host state, of the investor's, rights, and not to have deprived the investor of its investment treaty protection. But those kinds of cases are quite rare, where the human rights regulation of a host state is found to be predominant or permitted over the investment protection rights of the investor. And so we have well-rehearsed reasons for this, for why human rights does not often feature prominently. These include jurisdictional issues, also applicable law challenges, and really, in short, international investment law and international human rights law are often considered to coexist but separately in two distinct fields that arguably don't overlap. And many consider that investment arbitration is actually somewhat of a self-contained regime. So we're seeing this sort of debate back and forth. We do start to see, though, more states raising arguments under international law and effectively saying that investment treaties should be interpreted in line with international human rights law by virtue of Article 31(3) of the Vienna Convention on the Law of Treaties, which does permit the interpretation of treaties consistent with other relevant rules of international law. So this is a vehicle potentially for more intersection between the two regimes. And we have seen that argument accepted by some tribunals. Again, in the Latin America context, an example would be in the Overy versus Argentina case, where the tribunal held that indeed the investment treaty needed to be construed in harmony with other rules of international law, of which it forms part, including human rights law. Now, in that case, while the tribunal did admit a counterclaim, it didn't find it on the merits to be a worthwhile counterclaim, so that failed. But we did see one attempt by a state that was successful in arguing this point on the intersection between international human rights law and international investment law. Now, this hasn't been successful in other cases involving Latin American states, the example of South American silver versus Bolivia, where the case concerned the alleged expropriation of a mining concession that was in an area inhabited by indigenous peoples. There, the tribunal found that indeed the investment treaty protections for the investor effectively trumped the human rights obligations of the state. And that really was based on the idea that the express provisions of the BIT should prevail over importing provisions from elsewhere. And likewise, similar perspective in Bear Creek versus Peru. There was a famous dissent in that case from Philippe Sands, which argued that really that isn't the appropriate way to interpret a treaty, and that it would indeed be appropriate to deduct compensation afforded to the claimant based on the fact that the investor had contributed to human rights impacts and the loss of a license to operate. So there's really been, because of this tension, we're starting to see now states interpreting their treaties in accordance with their own human rights obligations, but also starting to expressly include these kinds of provisions in their treaties for the avoidance of doubt. So, for example, we see now in some of the bilateral investment treaty model clauses, we see the inclusion of human rights commitments. An example is in the South African Development Community Model, BIT, which requires investors to meet minimum standards for human rights and act consistently with international human rights law. We see it also in the 2018 Dutch model BIT, which has a provision whereby the compensation that an investor would be awarded in any dispute must take into account whether an investor is in compliance with human rights commitments and the UNGPs and the OECD guidelines. And then turning to Latin America, we have the Colombia model BIT, where an investor must accept the binding obligations established under the human rights and environmental treaties to which the parties to that treaty are party. So we do start to see a potential for human rights to be expressly included in these in future treaties, as well as then the direction that those would provide to tribunals to take into account international human rights standards. I want to quickly move to commercial arbitration, where we are starting to see also more attention to human rights in commercial arbitration. Now, once again, international commercial arbitration is not usually a venue or a landscape in which you see human rights issues feature prominently. Martin will have covered some of the reasons why you don't. Again, there are obstacles, and the main one being consent, that international arbitration is a creature of consent, and you don't tend to see commercial parties consent to arbitrating human rights issues. At the same time, I think recent developments in the legal landscape may augur a future where we will see commercial parties more willing to discuss human rights issues and commit or consent to the arbitration of human rights issues. This is coming, I think, out of the pressure that companies are feeling because of the ESG agenda that Martin mentioned. Pressure is coming from regulators, stakeholders, litigants, and other investors in order to make commitments on human rights binding, binding in supply chain contracts and binding in other contracts with relationships whereby one party would particularly not want to be implicated in the human rights impacts of another, and they want to make commitments binding and enforceable. And arbitration is an appropriate and I think attractive method of dispute resolution for commercial parties, particularly where sensitive reputational issues are concerned, if it's a dispute between two businesses, they might find arbitration much more appealing if you are going to enforce a human rights commitment in a contract such that it can be done behind closed doors and without all of the reputational impact. Now, there's sensitive issues, obviously, if we're talking about arbitration between businesses and actually affected stakeholders or victims of human rights abuse. And that's where the modifications that came into play in the Hague Rules are of particular relevance. And as Martin said, I think the proof of concept for those kinds of arbitrations comes from the Bangladesh Accord arbitrations. And so I'm going to, with that, transition to Christy to say that I think that hearing about how the Bangladesh Accord operated is really, there's no better way to explain why businesses might, in specific circumstances, be willing to arbitrate disputes between themselves and actually affected rights holders.
All right, so I guess it's over to me. So thanks for the invitation to join you today. And yes, always a pleasure to talk about the Bangladesh Accord and the aftermath. And we've just recently negotiated a new accord with a new arbitration provision, slightly different from the old, but I'll get to that in a minute. We negotiated, first also, I should just clarify one thing about myself. It wasn't in my introduction, but I am also a lawyer and had practiced labor law in the United States for about 20 years before I entered the international arena. And so I've had a lot of deep experience in arbitrating labor cases in the United States. And that's kind of that was my experience coming into this with arbitration. When we negotiated the Bangladesh Accord, I think most people are surprised to know how quickly the accord was negotiated. It came on the aftermath of Rana Plaza, and somewhat, a lot of energy to get an agreement quickly. The brands were under tremendous pressure to show they were serious about having a never again moment in Bangladesh. But equally, there'd been years and years of social audits and all kinds of, in fact, Rana Plaza itself had been audited not too long before it collapsed. And there was a strong momentum around having a binding agreement, that we would not be willing to sign a voluntary agreement, and that we would have a binding agreement. And so we really negotiated it in the space of a couple of weeks. Now, there had been precedent, there'd been a preceding agreement that had been signed by a company in the United States with an arbitration provision as well, but it was only one company. Now we're dealing with hundreds. So we negotiated the Bangladesh Accord in a the arbitration provision had to be in it from our perspective. I represent a global union, and we were working with another global union that works with the workers in the factories, and we represent the workers in the stores. So we were negotiating with the big brands like H&M and Zara, and all the big European brands were really in the lead, but some from the US also in the group. And the arbitration provision was not that controversial because we used UNCITRAL rules, and the commercial, the commercial side of the deal, they were pretty comfortable with UNCITRAL rules. There was never any question that it would be enforced under national law, because we had so many different, our intention was to have companies from all over the world, anybody who produced garments in Bangladesh, to sign this agreement. Now, the agreement itself requires the brand signatories, not the producers, but the brands who actually contract with factories to produce garments, to ensure that the factories had enough, were safe, but and that if they were not safe, according to our inspection protocol, they would withdraw from the factory. But also, and the key issue that we had a dispute over was also that there was financial means to repair the factories. And this question of whether or not it was the brand's obligation to pay for the factory remediation, or it was the factory itself that was required to pay, was a question that was in dispute. for a long time between the unions and the brands. But in any event, so the arbitration provision, let me just say the agreement of the accord was between the unions and the brands, not involving the workers. So the workers were not signatory to the accord. They did not have the right to bring an arbitration. It was really a contractual relationship, individual contracts between the union and the brand. Ultimately, 200 brands signed. So we had 200 separate individual contracts, but there was never any question that we would enforce these contracts across the whole spectrum of nationalities involved in the accord. Now, when we negotiated the accord, and I had not had any experience with Untitled rules, we missed a few tricks. We didn't put in choice of law. We didn't put in seat of the arbitration. We just said pursuant to Untitled rules. So all this stuff was messy when we finally got to an arbitration. And we tried at the beginning with our brands to establish a panel of arbitrators, because in a very specific kind of arbitration like the accord, it would have made it much easier had we already chosen a panel of arbitrators from which to draw for this case. We hadn't been able to do that because of the fact that we had these individual contracts. It was decided that each signatory would have had to separately agree to the panel, and that didn't really work. But I do want to, coming back to the question of why companies might sign this, they had to sign this. Nobody wanted to sign this, but there was no option. Once the big companies signed, everyone else came flooding in. We thought we might have 16, 10, 15 signatories. We had 200, and we still have 135 signatories on the accord, and there were now 8 years later. But it wasn't a question of, if I had my choice, I'd prefer a voluntary commitment. It wasn't on the table. And I think in that moment of crisis, it was sort of the pill everybody was willing to swallow. Now, I would say, and we negotiated this agreement in 2013, again in 2018, and again in 2021. And in 2018, we'd had 5 years of the accord. We'd had an arbitration involving 2 separate companies. And the brands were still willing to sign a binding agreement with an arbitration provision. And if you ask them privately, if you ask them publicly, they'd say, oh, we don't need binding. We're all going to live up to our commitments. If you ask them privately, they would all say, yes, it helps to create discipline, that we know that we're all held to the same standard, that we know we have a level playing field, that all the brands, that you could enforce against all the brands, and that it makes it a serious commitment. So nobody has really objected to that feature. I mean, we have plenty of other disagreements, but we realize we've achieved quite a bit over the years through having a binding agreement. Now, I just a few words about our arbitration. We had a dispute over the money, as these things often are. You know, that was one of the key issues, because it's unfair to require factories to remediate if you're not also willing to pay some of the burden of that, especially in cases where, you know, the price per garment remains still very, very low, even after 8 years of improving the factories. The price is even lower today than it was in 2013. But so this obligation for the brands to pay was so central to the success of our agreement. And we did bring 2 cases. And as Martin said, we had some procedural disagreements. What is the choice of law? You know, should it be Bangladeshi law? Should it be UK law, which some argued, you know, is it the national law? Is it the Dutch law? So there was that. There was a seat of the arbitration. There were questions about confidentiality, and there was a question over whether or not, in fact, the dispute that the agreements that we had was actually a legally binding agreement, because argument was there was no consideration. But you know, we got through those hearings, and then we were preparing for the case to go to hearing, and we achieved a settlement, as one often does when you're in arbitration. You're able to get a settlement. We were very happy with the amount of the settlement. But I would say that what we realized through this process is that the pleading requirement, from our perspective, the heavy requirements of UNCITRAL, the procedural requirements, the pleading requirements, the 3 arbitrator panel, was a huge expense for unions to pay for that. We were not paying for it. We had pro bono counsel, but I think it's important to put that on the table from our point of view. It would have, had we gone to hearing and finished the process, it would have taken quite a long time from the perspective of, we look at it as a labor dispute. And I know it's not a classic labor dispute, how much are the workers going to get paid, but still dispute between a union and a company. We looked at it in that context, and we also look at it in the context of, we want arbitration to be a model for international disputes. We have agreements with global companies about rights, the traditional fundamental labor rights of workers. We have signed over 50 of these agreements, and we often put in a clause that they'll be arbitrated if there's a dispute, but there hasn't been a mechanism for us to use for arbitration. So we're very much interested in creating a model that can be replicated not only in the Accord, but in other agreements. And so based on that, after we settled these cases, we devised a plan. And by this point, later on, the Hague Rules had been adopted. So we've been in discussions with the PCA about a new model for labor arbitration, which is even more slimmed down than the Hague Rules, but that we think will be something we can use in the future with the Accord. And that those rules, which we call the International Labor Arbitration Conciliation, have been written into the new Accord. I don't think even the PCA knows this, not as the only option, but as an alternative to Untitled, if we should decide that we agree to that, because we actually think that the brands would agree to the Hague Rules or to the ILCA rules, ILAC rules, I should say. The Untitled rules were expensive for them as well, and they complained a lot about it, and that was one of the things that drove settlement. And so we're very enthusiastic about developing, practices around arbitration that are both afford due process, but also affordable for the parties, and quick, because in this labor environment, we think we need it to be a little bit quicker and a little bit less onerous on some of the procedural things, and that we're also leaning towards a default position of one arbitrator only. So, and I think arbitration has gotten a good start with the Bangladesh Accord, and honestly, there's still today 135 brands that have re-signed just recently, just last month. We signed a new agreement, and there's a fair amount of comfort in this environment where there's such high stakes and such an important issue as safety in factories. It gives an extra bit of credibility to the relationship, and I'm optimistic that it's a model that will expand in the future.
Thank you very much, Christy, for this first-hand explanation on the ideas behind the Bangladesh Accord. It was fascinating. And I therefore give the floor to Eduardo, who will bring the focus to Latin America and explain to us the challenges of arbitrating business and human rights in Latin America. Eduardo, the floor is yours. You are on mute, Eduardo.
Working. Thank you, Gustavo, and thanks very much for this kind invitation. I must take the approach from a starting point, which is that we cannot refer to Latin America as a one single entity, as a one single package, as a one single country. So the first challenge would be to understand where is each jurisdiction in Latin America and try to understand where they come from. As you may know, part of the origin in a significant number of Latin American countries, arbitration is a sort of a parallel system to the courts. It was originated as a system to assist the courts and take out some of the workload of the courts. And therefore, as a result of that approach, one of the things that one still finds in Latin America is that arbitration is considered as a, and I put that in a big quote, alternative system. That has a twofold result. On the one hand, the judge is still considered as sort of the natural judge. The judicial system is the natural judge, and arbitration is, in some instances, the exception. So there would be some resistance, I can envision, to including in arbitration issues of human rights. So because of this particular approach, and then the first challenge would be to convince the states, the governments, the actors, that this is something that you can arbitrate, that this is something that you can decide by arbitration. Remember, in addition, that generally what you can arbitrate in most Latin American legislations is what you can settle. Only if you can, if the disputes refers to rights that you can settle, then you can go to arbitration. So the big question is going to be, are the rights that we are disputing under these clauses referring to human rights? Are those matters that can be settled? That will be, in my view, the first important challenge. The second one is that the different countries are in different stages of evolution, and we will find more difficulties in certain states than in others. I would say that Mexico and Peru, for example, would be countries that are extremely open to arbitration today, while others are open but have certain restrictions when the arbitration involves certain sensitive issues. That is the case, for example, in Colombia, where you have Colombia is open to international arbitration, while the courts want to retain some control on issues that they consider should remain in the control of the courts. And then you have other jurisdictions where arbitration is basically prohibited or tremendously restricted. So the second challenge would be to understand these nuances and differences and have a totally different approach to the totally different jurisdictions. Third, you have jurisdictions where you have a monist approach, and probably there the implementation would be simpler than in jurisdictions having a dualist approach. When you have national arbitration and international arbitration, probably you will find a situation where the rules could be accepted in international cases, but not in domestic cases. That is something to be considered in addition. The other key issue for me is that amongst the actors that you find in issues of human rights, you have states, of course, but you also have state entities and state corporations. And there are legislations where state entities and state corporations can submit themselves to arbitration with very restrictive, in very restrictive cases. For example, going to the issue of human rights, you could submit to arbitration the consequences of the act of the state, but not the act of the entity itself. That will be one restriction. Second, you will find restrictions where the state entity or the state corporation is allowed to submit to arbitration, but only under the rules provided for in the law. In other words, the state entities and the state corporations are not allowed to agree on rules of arbitration other than the ones provided for in the law. So that, again, would be a challenge. The other two issues that I would mention would be, number one, of course, and that would be an issue that would arise in terms of annulment and in terms of enforcement, is the issue of arbitrability. Is this arbitrable, and if so, to what extent? You know that the approaches of the different jurisdictions to what is arbitrable and what is not depends on the law, and the approaches are different. As I mentioned in the beginning, some jurisdictions simply consider that everything is subject to arbitration. That is the approach of the Peruvian law, which even has a mandatory arbitration, while other jurisdictions have a very restrictive approach of what can be arbitrated and what cannot. So then again, you would have different approaches to that. And a key issue in this thing is that, as you know, there is as we have a pandemia in terms of health, we have a legal pandemia in Latin America, which is the amparo or tutela, which is a constitutional challenge against awards and decisions. And this particular set of rules and these particular issues, this particular type of arbitrations would be open to challenges of alleged violations of constitutional rights, I would say, more than any other type of award, because of the issues being disputed. So that would be, again, a challenge to handle these constitutional actions. There is a great effort today in Latin American jurisdictions to reduce the influence of these constitutional actions and to eliminate, to the extent possible, constitutional actions against awards, arbitral awards, something that Mexico, for example, has accomplished, but still is an issue to be discussed. So I think the rules in themselves would be a great tool, particularly because of the issues of human rights in Latin America. I don't need to go into detail that this is an area of the world where human rights issues are at the order of the day. But there are significant challenges ahead. The main one, and I go to the beginning, the main one being understanding the substantially different approaches that the different jurisdictions have as to what can be arbitrated and what cannot. You cannot try to promote, to call it somehow, the rules in the same way in Brazil that you would do in Colombia. And you need a clear understanding of the dramatic differences that we have in the approach to arbitration in the region, including, and I forgot to mention that, the approach to what is public policy and whether or not this affects the public policy of the state, which would be a challenge, and Martin mentioned to that, and the rules refer to that. It would be a challenge in terms of the enforcement of the award in the different countries in the continent, because you go from jurisdictions where the concept of public policy is international public policy and an extremely restrictive approach to what is public policy, to jurisdictions where public policy means basically any imperative norm of law. So again, there would be a challenge there in that regard. That's basically what I wanted to share with you, and thank you very much, Gustavo, for your invitation.
Thank you, Eduardo. Thank you very much for our presentation. And I noticed that while you were dealing with issues of enforceability and arbitrability, Martin was taking some notes. So I would like actually to ask Martin if you would like to have the floor to address some of these issues and whether the Hague Rules have foreseen and the drafting team has foreseen this kind of procedural issues related to arbitrating business and human rights disputes.
It definitely foreseen those issues. They're coming, and a lot of those same challenges that Eduardo was mentioning. There, whether the Hague Rules have solved them, I think the answer is probably no, and certainly not for all situations. And I think that is perhaps the hubris in some manner of the Hague Rules there, just as I was alluding to the UNCITRAL rules trying to be appropriate as a one-size-fits-all solution for absolutely all kinds of disputes at all levels. The Hague Rules obviously had as their ambition to encompass voluntary commitments being rendered binding versus just existing human rights obligations. Their business to business commercial disputes, but that involve human rights issues such as Suzanne was alluding to, as well as V2B disputes but directly between rights holders and businesses. And I think and then you can take international disputes as well as those that might be characterized as domestic disputes that Eduardo was alluding to, and clearly they already failed on that account in the sense that Christy was alluding to, that there was already a desire to take the Hague Rules and then to even customize them further to the very specific context of the international accord, and the procedural specificities and the interests of the stakeholders in that area. However, that's where, again, to return to my optimism, I still think you have a large space, especially in Latin America, for what are voluntary commitments that are rendered binding, that aren't claims that are necessarily directly related back to existing law, existing obligations, would not be the subject of an amparo, as Eduardo put it, where you already have stakeholders meeting in the middle. They are agreed on the dispute resolution mechanism. You might have somebody upset with the outcome and still seeking collateral attacks upon that decision at the end of the day. But my hope is that by that point, the reviewing court has seen an award rendered within a process that has been designed specifically to take all of these situations into account by expert arbitrators who are authorities in this field, who have well reasoned exactly why their decision is rights compatible and compatible with all applicable law, so on and so forth, and that the party who is seeking to leverage arbitrability or enforceability after the fact will be given short shrift by a court, whether as a matter of the lex arbitri in play or the provisions of the New York Convention, or outside of that, just courts having been given discretion to still enforce obligations outside of those particular frameworks for commercial arbitration. And there I might point to the Iran-US Claims Tribunal, which was a strange beast unto itself. And that's precisely what we've seen with a lot of those decisions, is that courts have enforced those decisions, whether or not they were able to place them into the nice categories of the New York Convention at the end of the day.
Thank you, Martin. And here we'd like actually to ask Suzanne or Christy if you would like to comment on that as well, on arbitrability and enforceability, or we could go to the next question.
I'm happy just to echo the comments and say that, of course, just to situate the comments that have come before in the New York Convention. And the New York Convention, of course, talks about a dispute that is commercial in nature. So you have to consider that. It also talks about arbitrability under host, under the applicable law. And then finally, when it comes to enforcement, it talks again about the subject matter of the difference being capable of settlement by arbitration under the law of the host country, or needing to be consistent with the public policy of the host country. And if those criteria are not met, technically, recognition and enforcement of an arbitral award may be refused under the New York Convention. And so that's why all of these issues come to the fore when considering what types of disputes you might subject to arbitration. And that's also why I talked about how I think there's not as much of a problem when you're talking about what Martin would refer to as B2B arbitration, business to business arbitration, when you're talking in a supply chain or in any other context where businesses have an incentive to ensure that those with whom they have business relationships are adhering to a set amount of international human rights standards or a code of conduct that's incorporated by reference into the supply chain contract, etc. Those disputes are much easier because there's a commercial arrangement and it might satisfy the other criteria I just mentioned under the New York Convention. Where you have more difficulty is in the different kinds of so-called business and human rights arbitration, when you're dealing with actual rights holders in terms of affected populations. Then you have all of these potential issues as to whether it's a commercial dispute and also whether it's against public policy in the host country, or in the case of the Colombian Constitution, an issue that can't actually be settled that can't be settled according to human rights issues within the constitutional framework. And again, these are the issues that need to be dealt with on a case-by-case basis for each potential use of arbitration.
Thank you very much, Suzanne. Thank you very much. So luckily, we still have some minutes to the end of our webinar, and I believe there is room for one question that each one of you would be able to tackle a little bit. And I think it's in the back of our mind when we hear you all discussing business and human rights arbitration, which would be, why arbitration? Why not domestic courts? So maybe if Christy would like to address this first, as Christy comments about the movement towards arbitration, this would be great to hear from you. You are on mute, Christy.
Since we have an international agreement with more than 20 nationalities of the signatories, but we're not interested in litigating that agreement in 20 different countries, 20 different courts. Some of our brands have said, we should be in Swedish court or Italian court or German court, but it doesn't create any case. It doesn't create any new policy. Doesn't interpret the agreement in a way that could be taken. It could be interpreted. The agreement could be interpreted differently across different courts. That's one issue. But also, as an international organization, we just don't want to be litigating all of our disputes with employers in their home country. It puts us at a big disadvantage, and it's not the arena that we think should apply. Now, some companies have argued very vociferously that it would be a lot less expensive and faster if they could just go into national court. And after all, it's a contract dispute. It's a question of contractual interpretation when you're looking at our agreement, which side is right. And the law won't differ that much from country to country. There's a little bit of difference on extrinsic evidence and so on, but in terms of contractual interpretation, I think there's a point there. But we still think that it's not the right way to handle these international agreements, and that there should be a common decision-making process. And certainly, it wouldn't be uniformly the case that national court litigation would be easier or faster or more fair. It might be better in some countries, but it's not a gamble that we would be willing to take. And frankly, I don't hear that many companies anymore arguing for national courts to have jurisdiction. I think there is an understanding that it's an equal scenario where all the different companies from different countries have the same dispute resolution process, and they end up in the same place. I think there's a certain coming to terms that this is the right way to go forward with these issues.
Thank you, Christy. Martin, some of these points have been a topic of discussion of the drafting team towards understanding the interests of the parties to arbitrate these disputes. Cannot hear you.
Sorry about that. Double muted and double unmuted there. No, I think the only thing that I would add to what Christy was just saying is precisely the general advantages of arbitration also play out in this particular field. I mean, if both sides and indeed the stakeholders have crafted a dispute resolution mechanism that they see as bringing neutrality and expertise to the table, that they see as being fit for cases of very significant importance, whether they're the ones who are acting as the claimant or the respondent there. Why wouldn't they prefer those advantages to national courts? Why wouldn't they see this as a better forum for them to be submitting these disputes to? And I think that played out in part in some of those investment cases where the investor consented to jurisdiction over counterclaims being brought against them by the state. Once they had put a bet the company case on the table before a tribunal that they had placed their trust in to decide the claims that they were bringing against the state, why wouldn't they trust that same tribunal to decide the claims that were being brought back the other way by the state against them?
I can just
Suzanne?
maybe jump in. Yeah, thanks. I mean, I think this is another illustration of why it's so important to focus on a case-by-case basis on the given scenario, because of course we've also heard a strong discourse in the United States about how arbitration actually is a violation of rights of stakeholders in the sense that compulsory arbitration and that there aren't protections in arbitration that would be available in domestic courts. And of course, that's one scenario that it would be different from a scenario that Christy's talking about, where the stakeholders themselves have crafted the dispute resolution methodology and are comfortable with it, and also recognize that it's much preferable to have a consolidation of claims all in one forum rather than a multiplicity of jurisdictions and parallel proceedings. So there are very good reasons in the context, for example, the Bangladesh Accord, but there might not be good reasons in other contexts where you're dealing with vulnerable parties who actually might need protection of host state court. And that's the animating principle behind the non-arbitrability of certain types of disputes. For example, constitutional rights are thought to require the protection of a court as opposed to an arbitral tribunal. So it's just I just wanted to flag that, you know, it really is case specific as to when arbitration might be appropriate for a certain kind of issue.
Thank you, Suzanne. Thank you. Any other flag to be?
I would add simply, I would agree that arbitration is the way of solving disputes between international disputes, whatever the nature, including the B2B disputes that we're debating here. The challenge would be mostly in local arbitrations or arbitrations involving the victims, the parties affected, and why arbitration? What I would see is a reaction of the state saying, well, we have the courts are, again, the natural place to go, is the natural judge. Why would we go to arbitration for this? The only reasonable response would be time, efficiency. And I want to just briefly comment on an experiment that was done here with the Chamber of Commerce of Bogota, when Rafael Bernal directed. He did for 3 or 4 years an experiment of small arbitration cases involving all sort of issues, inviting well-known arbitrators to decide the disputes. The parties will sign the agreement for that particular dispute, and it worked beautifully. And there were like 400 cases resolved in a weekend. So that sort of thing could work if you convince people that it would be possible in local arbitration because of efficiency and cost and time, as opposed to going to the court and, at least in Latin America, stay there forever.
Thank you, Eduardo. Any other comments about this? So actually we reached our time perfectly. So with these final remarks, I would like to thank the speakers for this extremely enlightening discussion. Thank our host, the American Society of International Law, and the audience. So that's the end. Thank you very much.
Thank you. Take care. Stay safe.